All right, thanks so much for being with us here on Atlanta News First Plus. I'm Joy Lim Nakrin, joined by attorney Josh Schiffer here in studio. Thank you so much again for being with us. So, Josh, we've got several top legal stories that I'm so happy you're able to join us to talk about here today. First thing that we have been talking about already before we started off this live stream is what is facing Fulton County District Attorney Fani Willis. Just this morning, there was a new subpoena from the House Judiciary Committee that came in the form of a letter from Congressman Jim Jordan, and it is a document subpoena. First of all, what is your reaction to this new development?
It's not unexpected. DA Willis and Jim Comer have been in regular discussions and contentious ones where the House of Representatives has asked her previously for explanations, documents, responses involving the alleged relationship in her management of the Fulton County DA's office, specifically in relation to the prosecution of former President Trump. What we've seen today is an expansion of that investigation. A subpoenas ducis tecum is a subpoena for the production of documents. Traditionally, that is less onerous and difficult for someone to comply with because it's forwarding documents which are often previously already collated because they're involved in other matters. This adds to her multiple issues, all happening on a very important day, that being today, Friday, February 2nd, her response for the Mr. Roman's motion for disqualification to be heard in front of Judge McAfee on February 15th is due today. And there are big questions about what her response is going to include, as this is going to be the roadmap for the next several weeks in the Fulton County versus Donald Trump case.
Okay, so, the timing, we've been talking a little bit about the timing here because another important note here is that by the end of business today, Ms. Willis, and you touched on this, like you said, her response is due in the Romans case. Again, Michael Romans is a co-defendant of former President Donald Trump, and his legal team has sued Fani Willis, alleging that basically that she's interfered with access to documents that are important to their allegations of impropriety by her and essentially her office. So I'm curious about just if this was really strategic, that
yes.
We knew that there was this deadline. It's been widely reported, this deadline by the end of business today for Fani Willis to answer the lawsuit. And then just a few hours ago, she gets a subpoena from the House Judiciary Committee. I mean, is this collusion?
It's hard to say collusion because it could also have just occurred absolutely naturally and organically. When you take apart the various different issues DA Willis is facing, they each stand by themselves individually. However, collectively, they relate to the same core issue, which is DA Willis's management of her office during these high-profile prosecutions. Miss Willis was the recipient in the Trump case of this Roman motion. That is a motion from Attorney Merchant, where the Miss Merchant, on behalf of Mr. Roman, is asking to basically disqualify and kick off the Fulton County District Attorney's Office due to the inappropriate, allegedly, relationship between Miss Willis and her chief specially appointed prosecutor, Nathan Wade. That brought in the divorce. Mr. Wade is going through that divorce, and there are questions as to how he has responded and what the process of that divorce includes as it relates to Fani Willis. That's a private civil issue, but it pours over into her actions as an elected official and also as a chief prosecutor. In addition to that, we've got the brand new case that was filed, which is the Freedom of Information Act request refusal case. Now, in the United States, we have a very strong law involving sunshine and being able to find documents. It is at the heart and soul of the entire journalistic profession because we deserve to know what our government is doing. So under the Freedom of Information Act, you are allowed to require state agencies to release certain documents in certain time frames within certain parameters. And Ms. Merchant has recently, as in the last couple of days, filed an additional matter claiming that the DA's office is stonewalling and slow-walking these responsive documents specifically because they respond directly to the allegations involved in the hearing that we're going to have on February 15th. That hearing on February 15th is what Fani Willis's response is due for today by the end of the day, and it's what we are all waiting for.
Josh, just getting word that we actually have obtained a response from Fani Willis, or that there has one has been filed. So our news team just working to actually gather that. We're going to have that printed out, and we're going to go through it together live here on our screen.
Fantastic. Now, this is going to be a response to the response for today. This is the second. That was the date that Judge McAfee had set for a response to the Roman motion filed by Merchant, with the hearing scheduled for February 15th regarding whether Fani Willis's office should be precluded from participating in the prosecution of President Trump due to the alleged inappropriate relationship with her chief appointed special prosecutor, Nathan Wade. And that sure is a mouthful. So this response is everything we've been waiting for. I can't wait to read it.
Yeah, no, it absolutely is. And you know, I mean, it's really, now it's hard to keep track of all of the developments that have surfaced surrounding these allegations of impropriety. And, you know, if people aren't really kind of political watchers, they may not have followed all the developments. But again, this all stems essentially from Michael Roman's lawsuit a few weeks ago, or I should say motion to disqualify Ms. Willis and Mr. Wade from the case. And that preceded the lawsuit. He filed a motion. His legal team, Ashley Merchant, his attorney, filed this motion essentially saying they should be disqualified from working on the case, and that the charges should be dropped because there was this inappropriate relationship happening between Special Prosecutor Nathan Wade, appointed by Ms. Willis, and Ms. Willis herself, among other things. And so out of this, we have so much fallout. We also have this lawsuit filed by Mr. Roman's legal team. We have the House Judiciary Committee subpoena, which is somewhat related. And then here locally, of course, our local lawmakers formed a committee to also investigate Fani Willis because of this. And then obviously the divorce case between Jocelyn Wade and Nathan Wade, that had been ongoing, that regardless of all of this. But, you know, certainly there was much more focus on that as a result. And new developments there, and then there was a call by, I believe it was Ashley Merchant, to actually open the records on that divorce case, right?
That is correct. That case, the divorce case filed in Cobb County, just northwest of the city of Atlanta, that case was inexplicably sealed, and allegedly sealed using improper methodology in front of Judge Thompson in Cobb County Superior Court. So recently, in the last couple of weeks, we had that dramatic unsealing, but of course it didn't tell us anything because these are bare bones family law filings, and I don't think any serious lawyer thought that there was going to be some groundbreaking bombshell. But what it really allows for is the continued exploration of the dynamic and relationships within that divorce. You can read all about that in the media, specifically allegations of infidelity between the parties. There are questions as to the financial arrangements. And anytime there's a divorce of middle-aged or later people with successful careers and children being raised, these are high-stakes, high-emotion issues. By combining that with the inherently political issues that Ms. Willis is involved in, this has the recipe for a disaster, an explosion that could absolutely detract and distract from Ms. Willis's obligations as the elected district attorney of Fulton County. What really gets fascinating in Ms. Merchant's motion on behalf of Mr. Roman are allegations involving not just ethical improprieties of the properness of having a relationship with a subordinate. There are some Fulton County human resources policies, but the financial issues of how Fani Willis decided who, what, where, why, and how to pay Mr. Wade, that is of extreme interest to the Roman universe, because if there is a benefit that flowed from the pay to Mr. Wade to Fani Willis, that's a huge ethical problem.
Yeah.
That's on top of many other facets.
Right. And of course, you know, as soon as we can get our hands on this answer, we're going to be able to, well, see how she's responding to those allegations. But I also want to just connect the dots back to this subpoena, this document subpoena from the House Judiciary Committee that came out just a few hours ago this morning, because one of the allegations there by the House Judiciary Committee, I mean, really the fundamental allegation, their biggest, is misuse of federal funds. And not just misuse of federal funds by Ms. Willis, by her office. We are just learning that this answer by Fani Willis to the lawsuit filed by Mr. Roman, again a Trump co-defendant, is 176 pages. So
that's going to be something. Now, I'll tell people there's almost certainly a bunch of exhibits attached to that, and very often that can really add to the page count. But that is certainly a substantive response, regardless of what you think. And that's interesting considering that Steve Sadow, who is the primary defense attorney for President Trump, posted yesterday or day before that a kind of set of questions, almost daring Miss Willis in her response. And this is public drama at its highest.
Public drama.
Very rare
Yes.
for anybody involved in a criminal prosecution to go to the press or to go to social media. But Mr. Sadow, who is a deeply experienced and sophisticated criminal defense attorney, one of the best in the nation, he knows what he's doing. He is working not just the court itself, but the court of public interest. And really, that's another battle that we haven't talked about.
Well, that's what I want to ask you about. So obviously Mr. Roman is a co-defendant of Mr. Trump, was also indicted in this RICO case, this election interference case by Fani Willis and Nathan Wade. But Mr. Sadow could have easily adopted that motion.
Absolutely.
That Mr. Roman's attorney, Ashley Merchant, filed. You know, he could have jumped on that bandwagon to have Ms. Willis and Mr. Wade disqualified and to have the charges dropped on the basis of that.
I believe he actually did adopt that motion with an additional,
He did?
yes,
Okay.
with an additional filing, I want to say. But they are all traveling together
Okay.
in this request.
So this is just into our newsroom just moments ago. This is actually, we got to take a minute and actually look through this. So this is the answer. This is the answer to the lawsuit filed by Mr. Roman's team. Here it says, let's take a look at it. Sorry, we're going to have to share a little bit. State's opposition to... I'm going to pop up video so you guys don't have to see us scrambling around. State's opposition to the defendants Roman, Trump, and Chile's motions to dismiss and disqualify the district attorney.
Conveniently, they have summarized at the very top kind of the main points, and they track directly with a lot of expectations that we've had in the criminal defense and criminal justice community. Mostly that Miss Willis, District Attorney Willis, is stating very forthrightly that she has no conflict of interest financially that would justify a disqualification, that she has no conflict of interest that justifies her disqualification personally or that of the Fulton County District Attorney's Office outside of financial, referring to the personal conflict issue. She states that the attacks on Special Prosecutor Wade's qualifications are incorrect, unsupported, malicious, and are basically inappropriate. She is claiming that D.A. Willis has made no public statements that would require some sort of disciplinary action or were outside of her mandatory ethics as an elected prosecutor and as a member of the Georgia Bar that would justify any kind of disqualification or judicial immunity, and that the criticisms of the process of the appointment do not provide any kind of legal basis for a dismissal of the claim.
And
so
then,
as we expected, she is not commenting on the actual allegations as much as stating that they are irrelevant, unimportant, and do not have a sufficient basis to affect her participation.
and you didn't even read page 3 yet because I didn't give that to you, but it actually says here, page 3 of this, the motions attempt to cobble together entirely unremarkable circumstances of Special Prosecutor Wade's appointment with completely irrelevant allegations about his personal life.
And this fits exactly what many people believed she was going to do in not addressing the specifics of the relationship and the allegations involved in the relationship. And Admittedly, there has not been verification or proof. There is a lot of speculation and some documents out there. It's easy to make some conclusions, but she is decidedly not going to confront the allegations specifically in writing. She is setting out that this is basically a ploy by the defense.
And actually, the language here on page 3 is a manufactured conflict of interest on the part of the district attorney.
Weaponizing the ethical rules of our state, something that has happened. We have a long tradition in almost any system, judicial system, based on, conflict, and that's what our system is. It's always a fight, and what this is she is responding that the delegitimization of her position is manufactured, incorrect, and only being done because it's the way the defense can move the needle and win.
So
She's saying, come to court and argue your case. Stop talking about all the fluff in the background.
So this is really interesting. Speaking of fluff in the background, okay, here's from page 11 in the motion. I don't know. I'm going to hold this up to the camera. That is something. But so this is the claim here in this motion is that this is Ashley Merchant. That's the attorney for
I can tell.
Mr. Roman. And here it says in this motion, that the counsel for defendant Roman, Ashley Merchant, is well familiar with the experience and essentially, help campaign for Mr. Wade.
I'm going to say that looks a lot like Ms. Merchant,
campaign.
a woman that I've known for 20 years and a very highly respected member of the bar. And it doesn't surprise me at all that she was involved in Mr. Wade's campaign for judge in Cobb County, because I happen to know that that is her primary jurisdiction that she operates in. She is a long-standing member of the Cobb County community, and Nathan Wade's race for a judicial position on the Cobb County Superior Court bench was highly contentious. Judicial politics in Cobb County have a long history, and it does not surprise me at all that she aligned herself with his campaign at that time.
And so there, and I want to just let and we can let the viewers in on the conversation. That's the beauty of the stream. We're a little bit more intimate and just, we're real with you. We're actually going to bring in our television audience in a couple minutes here. Josh, I want to give you a heads up. So we're going to, if we do sort of an unnatural restart, we're playing TV at the same time that we're streaming here with you. But look, that's what the stream is. We're giving it to you pretty raw. But I do want to point out here in this motion that Ms. Willis and her team have filed. It says during a judicial campaign in 2016, defendant Roman's counsel, Ashley Merchant, who we've been talking about, and was an enthusiastic supporter of Wade's candidacy, described him in glowing terms in a May 2016 Facebook post. Remember, this is the thing that I was showing you, the Facebook post. Ashley Merchant actually describes why Nathan Wade, writes, why Nathan Wade? Nathan is ethical. Experience matters. Nathan's experience includes public servant, prosecutor, private attorney, judge. I'm sorry, I botched that a little bit. Nathan has practiced in every area of law that appears before the Superior Court bench. He's a recipient of the State Bar of Georgia's Justice Robert Benham Award for service to the community, a recipient of the Gate City Bar, et cetera, that Merchant was both a vocal and visual supporter in Wade's campaign. And so it really undercuts this whole argument by Ms. Merchant now that essentially, Ms. Willis hired Mr. Wade because it was her boyfriend.
I'm going to be pushed back a little bit on that, because Ms. Merchant's role as an attorney is separate and distinct from her role as a citizen and lawyer independently. One of the great parts about being a lawyer is that your personal mores and values do not have to align with your clients.
Well, can't you flip that on its head and say same goes for Miss Willis?
Absolutely.
That her personal life doesn't have anything to do with her life as a prosecutor?
That is what she is intimating. However, Miss Willis holds a very different position. As soon as you are elected as a constitutionally empowered officer of a state or county, you have additional obligations and responsibilities and ethical requirements in how you conduct yourself. You have higher duties than a regular person. And I think it's going to be very interesting if Miss Willis wants to take a tact that Miss Merchant is betraying her personal beliefs or is somehow not valid in her critique because of prior support of Mr. Wade in a judicial race, nothing about the issue at hand right now would preclude Mr. Wade from running for judge again. The issue goes back to the judgment call between Miss Wade and Miss Willis and Mr. Wade in having what is allegedly an intimate relationship. There are big questions over whether that's germane and relevant or not.
So I don't know how germane and relevant this is, but apparently, it seems to be because, the accusation, part of the allegations are that Ms. Willis appointed Special Prosecutor Nathan Wade because they were in a relationship, not because of his credentials. So part of this 176-page answer by Ms. Willis is credentials. Here he is. This is, that the President's Award to Nathan Wade, Judge Nathan Wade. Here is Nathan Wade, Georgia, one of Georgia's top lawyers, named one of Georgia's top lawyers. A presidential award to Nathan Wade. So this is what we've been seeing, and another recognition in support of the Bar Association of Younger Lawyers Division. So this is what we're getting is pretty much Nathan Wade's resume. We got a certificate of appreciation here. We got another certificate of appreciation here. So. That's what we're seeing, Josh, is...
Yep. And here's the issue. Nathan Wade was a highly respected and regular operator in the legal community in Georgia.
Okay.
It's one of the reasons that he was operating in the same orbit and has done the work necessary to bring him to Miss Willis's attention. In addition to this case in Fulton County, we are now going back and looking at prior work that Nathan Wade performed for different groups, including the Cobb County Sheriff's Office. Mr. Wade was retained, and there are some big questions as to the formality and appropriateness, the legitimacy of the services he provided in order to assess some jail death issues in Cobb County. At the conclusion of his work there were a series of lawsuits and complaints regarding what work he performed, whether he used appropriate professional duties, created the appropriate records, was appropriate as a lawyer for Cobb County on behalf of the Sheriff's Office. And those are now getting brought up. A very senior Cobb County prosecutor, Miss Cindy Yeager, actually went on the record here recently questioning the appropriateness of the work he had performed for Nathan Wade, and specifically questioning his qualifications to run a massive RICO case involving the former president.
So I want to also point out, that it has now been revealed, and it's something that we reported here on Atlanta News First just a few weeks ago, that before approaching Nathan Wade, Fani Willis approached several other, attorneys about
prominent attorneys,
right, including ex-governor Roy Barnes as well. So, and asked them if they would essentially take on that role as a special prosecutor to help lead in the Trump investigation. They said no.
Yes, absolutely. Getting involved as a special prosecutor would affect, obviously, your reputation, your practice, your family. It is not your average case by any means, and it doesn't surprise me at all that some of the most respected and relevant former prosecutors, current prosecutors, high-profile lawyers would want to stay away from the prosecution of former President Trump due to the political, kind of radioactive nature of the allegations. Regardless of what's brought out in court, due to the highly politicized nature, a certain portion of the community is going to be upset no matter what the resolution is.
Yeah, but I do, I hate to inject my opinion. Let me ask you your opinion, but do you think the fact that she tried to ask several other attorneys to take on that role before she ultimately settled on Nathan Wade, that is a very helpful fact for her?
It is a meaningful fact that she's going to be able to show that she diligently sought other lawyers to be lead on this project, assuming they were asked to be lead, and that after not being able to find the appropriate participants, she settled on Nathan Wade. And that decision, that's at the key of the questions. What were the influences of personal versus professional? Were there any? Was it appropriate? Was it not appropriate? Could it ever be appropriate? And outside the legal and ethical canons, let's just step back and talk about politics. Your job, if you're a DA, is to shepherd a case and be successful in prosecuting. There's a very legitimate criticism that having a relationship with anybody else on the team prosecuting the former president would be a bad choice optically and would distract from the case overall, harming the eventual prosecution. And that's going to go directly against Miss Wade,
So,
or
Josh,
Miss Willis.
I'm looking at this filing, and you know, I see some airline tickets, and honestly, just looking at it, it's not clear to me if this is a receipt. Oh, yes, it is a flight receipt, your flight receipt to Fani Willis, because remember, one of the allegations was that, you know, Mr. Wade was using the money that he got from his gig working on the Trump case to fly he and Miss Willis around. So here, she's got the receipt, and I want to show you. And I haven't read all 176 pages since it came up while we've been doing the live stream. I'm not sure the context here. I'm going to put my hand over this because I don't want to be offensive, although this is offensive in itself. This is one of the threats that Miss Willis has talked about receiving, that she is sharing.
Undoubtedly, she has been.
That is the N word that I'm covering up. That she is, she's clearly targeted with these threats, and she's called expletive N word.
Absolutely, and it's one of the things that all prosecutors face to some degree, but this may be one of the most egregious examples of someone standing up, doing their job, and suffering the slings and arrows of the community. Because I am certain Miss Willis is receiving the most vile and offensive threats from anonymous
monsters. And then
monsters.
I'm going to cover this because the image is so graphic, but it's essentially, you know, it's a lynch post, and it has her picture, and it says, "I'm past the point of wanting them in prison." And these are the kind of threats.
It does bring up a big question, though, is by interjecting the threats that she is receiving as part of her job, is that relevant to her actual prosecution and the questions being raised in the Roman motion? No one doubts that she is the target of millions of Americans are angry that she has chosen to prosecute the president, and millions of Americans believe that she doesn't have legitimacy to prosecute the former president. That's part of the job.
Yeah.
The question is that relevant to the question that Judge McAfee has to deal with, which is it ethically and legally appropriate for her to stay on the prosecution, or have her actions and the actions of Mr. Wade created a situation where justice is untenable, and it would be inappropriate for her office to continue?
We're still sorting through this 176 pages, and this is just some of it. I got more over here, but I do want to tell our viewers, if you want to read the whole thing and even join our conversation, it's on AtlantaNewsFirst.com. So go to AtlantaNewsFirst.com. You can see all 176 pages and sort through this, because a lot of it, you know, honestly, some of the threats that Miss Willis received are you know, they're very graphic, and I don't feel comfortable sharing it on the stream. But, you know, we encourage you to go there and check it out. Like, I'm getting upset. You can see that.
It's vicious, awful things. One of the unfortunate portions of anybody that works in the criminal justice system for too long is they are going to be exposed to the dregs of humanity and some of the most cruel and insidious concepts, images, and words that exist. And it's absolutely horrifying to think that so many public servants are subjected to this on a daily basis.
You know, this is a very long filing. Here, I want to give you a chance if you want to look through a little bit more.
Thank you. I'm most interested in her responses to the specific allegations that Ms. Merchant in the filing on behalf of Mr. Roman has made. I see that she begins by trying to extinguish the idea of any conflict. One of the issues with her being the elected district attorney is that if she is disqualified from working on this prosecution, it affects her entire office. And as we've discussed here at Atlanta News First before, if her office is disqualified, the Prosecuting Attorneys Council of Georgia, run by Pete Skandalakis, will be then tasked with finding a replacement prosecutor. And out of the many prosecutor offices in Georgia, the vast majority of them trend conservative. And
Okay.
there's been an extensive discussion on how charging the president isn't the business of Georgia at all.
Okay,
And
okay.
a different district attorney could choose a very different approach to this prosecution.
Yeah, no, absolutely. And I'm wondering, you know, it is because I mean, first of all, I'll say clearly that Miss Willis has sacrificed so much to be able to do this, to pursue this case that she clearly believes in. And you know, I don't want to editorialize, but just the threats, just reading the threats that she received, I will say personally upset me just to read. And for her to receive them, you know, I think it and to continue on, I think it speaks to how much she's put into the case for sure and how much she believes in it. That said, I do wonder if she ultimately would and should be removed for the appearance, basically to maintain the appearance of propriety and objectivity.
And she's directly addressing that in this filing with a quote from a rather, seminal state case where she is setting forth that any conflict must be more than theoretical or speculative. It must be an actual, real conflict, not the mere appearance or possibility of a conflict. But in order for her office to be disqualified, the court must find that there is an actual conflict, an actual personal interest in the conviction or non-conviction or processing of a case. That personal interest has to be substantial, and it has to be a real, actual, factual conflict. And her opinion and her statement and her position in this is that any relationship that she's having, all of these allegations do not rise to establish an actual conflict. She is positioning this in that the attack in the filing from Mr. Roman, as adopted by former President Trump, this is a manufactured red herring where rather than addressing the factual allegations included in the RICO indictment, the defense has created out of whole cloth a false set of conflicts in an attempt to collaterally attack the participation of D.A. Willis's office entirely. And that's going to be up to Judge McAfee to determine.
Okay. So it almost, because this just broke, it kind of almost buried the lead that we were talking about a little bit earlier, which is she has been subpoenaed. There's been a document subpoena by the House Judiciary Committee. No shortage of documents in that filing.
No, none. And I think that it would be very interesting to have some examination of what kind of documents and efforts were provided in these filings in comparison to what is being requested by the House Judiciary Committee, because some of them could be concurrent.
I want to ask you, so just because I'm getting we're getting a lot of comments on YouTube. Some of them are not appropriate, quite frankly. But one of them is a question that I would like you to answer because it seems to be a recurring question. Why hasn't Willis been arrested?
That she has not been formally accused by a law enforcement body.
There's no criminal charge here.
Well, there are discussions about whether there should be criminal charges.
At this moment, there's no criminal charge.
Very correct. There is not a single criminal charge.
These are motions to dismiss charges. These are motions to disqualify her from a case. There is a civil lawsuit. There is an investigation, but there's no criminal charge.
And that's going to be a very difficult examination. And remember, there are multiple overlapping law enforcement agencies, including the Georgia Bureau of Investigation, federalist authorities, various different state authorities that have the opportunity to bring complaints to appropriate judges and request an arrest warrant for the violation of state or federal law. It will be up to the elocution of those allegations and a judge to determine whether bringing a charge would be appropriate. And that's a really squishy part of the criminal justice system. You can get a bad warrant pretty easy. It's not hard to make probable cause for a charge. It's about finding the friendly venue and judge that would approve it. But all judges are basically equal. We have to trust, under the full faith and credit the actions and lawful orders of other judicial agencies. And for all I know, someone is working on some sort of charge right now against Fani Willis for some sort of supposed crime. That would add yet another layer to this onion. And what I'm seeing is a death by a thousand cuts totality of the circumstances attack against Miss Wade in an effort, Miss Willis, in an effort to basically make it so difficult for her to manage her message and do her job, she becomes impotent in her obligations to prosecute the president. Another angle on this, and one that was discussed extensively last night by myself and a number of other legal professionals, is why doesn't Mr. Wade take a high ground and walk away and resign? That is an option on the table, and many people feel it is the best option because that would resolve any potential conflicts involving finances moving forward between him and Miss Willis. Miss Willis also has two very competent, experienced, specially appointed prosecutors on this case, Miss Cross and Mr. Floyd, some of the just fantastic lawyers, and there are big questions. Why doesn't Mr. Wade step away in order to, quote unquote, save the case?
Well, and my question to you, I was just thinking about it today. Miss Willis has really been the target of, these various investigations, and the lawsuit obviously subpoenaed for the Wade divorce case. I mean, obviously, Mr. Nathan Wade has to testify in his own divorce case, and it seems very unbalanced. Why is that? Is it because she has a higher profile position as the DA versus Nathan Wade being the special prosecutor?
I think there's a lot of different strategies depending on your perspective. Mr. Roman's team obviously is throwing a very broad net and trying to wrap up multiple issues, creating a large set of complex issues that prevent progress on the prosecution. There may be other specific, more targeted allegations against DA Willis. With the financial issues coming out in this response, I won't be surprised to see some of the community organizations involved with financial propriety, different think tanks, other groups start to speak much more aggressively about taking some sort of public action to address these allegations. Remember, right now, Fulton County is just paying $900,000. If you look at the media right now, we had a county commissioner, Miss Hall, who was in the middle of a divorce, began an affair with someone that she hired to work for her, gave him raises, but unfortunately, as that relationship fizzled, it created a massive legal exposure from the employer-employee context of an elected official here in Fulton County, with the resulting legal settlement being $900,000 for what is otherwise a breakup. And that's the kind of fear that people have. What happens if the Wade-Willis relationship, if there is one, breaks down over the next 6 months? I've broken up with people. Everybody's broken up with people. It's awful. What happens at that point? These are some of the questions people are asking about the judgment executed by DA Willis in allegedly having an intimate personal relationship with the lead prosecutor in the biggest case she's ever handled.
Yeah. So what happens now?
I can't wait to sit down and read this very thoroughly. There's going to be a lot of both academic as well as pop culture analysis of how this lands. There are going to be people who stand up in full-throated support of DA Willis, screaming that she is only being targeted because of her prosecution targets, because of racial issues, because of the various disparities that exist, and they are going to be fully convinced that she is doing the right thing and support her strongly. All the way on the other end of the spectrum, there are going to be people that view this response as basically an admission of her inability to effectively manage this prosecution, because it's turned into a lot more than just a prosecution. We now have added rings to the circus, and the bigger that circus gets, there's a legitimate criticism. It's impossible for the best interests of justice to be satisfied with all of these collateral issues consuming the bandwidth of the court and the court of public opinion. So I'm expecting a wide variety of responses to this. We'll see how it settles over the weekend.
Yeah, absolutely. Let's go back to the divorce case for a second, because that's another piece of it, right?
Absolutely.
So is she still going to have to testify in the divorce case
Well,
between Jocelyn and Nathan Wade?
Right now, there's been this announced agreement which put a pause on the most litigious portions of that divorce. That was made, and it's been acknowledged, because money exchanged hands. The attorney's fees for Mrs. Wade and some spousal support were established in order to keep that case going and prevent the depositions that Miss Willis was concerned with. It doesn't mean that they are eliminated. That divorce is not fully settled. There are still plenty of opportunities for it to settle quietly as well as explode. And again, it's the future. I wish I could predict it accurately. What I would think is that Miss Wade has a lot of advantages in the optics in the divorce, and her lawyer, I'm certain, is going to try to take advantage of those to the best of her ability, just as Mr. Wade is going to be able to take the harm that he has experienced from this set of issues and maximize that for his best position in the family law case.
Yeah, and Josh, I actually am trying to take a moment here and read some of this, because it's 176 pages, and you know, let me give you a second. Let me hand you this for a second and see if we can kind of sort through this, because
One of the things that I want to note as well as
Yeah.
we're reviewing this is personal attacks and invective are an unfortunate reality in modern litigation. And I'll say that, you know, rolling around in the mud is pretty common.
okay.
This is getting muddier and muddier by the minute. And the more mud gets attached to it, the less clarity and integrity the system has. And if the defense in this case can create enough sideshow, enough mud in the water, prevent clarity, it will abrogate and destroy any legitimacy in the prosecution overall. That's kind of the more existential question. How valid is a prosecution when there's all this happening in the background? That's
Yeah.
a big one.
Yeah, absolutely. That's exactly right, and that's really the question, you know. And like Ms. Willis has said in this answer, you know, she called it a manufactured conflict of interest. Nonetheless, if it is, you know, manufactured, if it has become, and you know, many would say it has become a huge distraction, you know, maybe ultimately they get what they want, which is to disqualify Miss Wade, Miss Willis or Mr. Wade.
It's become a much more common tactic in the criminal defense universe at large to what we call it as reframing a case. When you have facts that may not benefit your client, you don't want to concentrate on them. So you reframe the conflict that is being litigated, turn it into something else. That is a big chunk of what the defense is successfully doing here, because think about what I'm holding. We are holding pictures of a defense attorney campaigning for the special prosecutor when he was running for judge. It's going deep, y'all. This is not just pick up the internet and look for some, no, these are deep investigations. I hate to think about how much this costs. This is not easy stuff, and these are high-profile individuals. The fiscal condition of the criminal justice system is of interest to everyone in America and this state. You don't have to throw a stone very far to find an underfunded victim program or a jail such as that in Fulton County that is so decrepit they roll dead bodies out of it pretty regularly. And here we are looking at 176 pages of work product from the most effective and sophisticated prosecutors in the county on behalf of the county and state. So that is a cost that Miss Willis has now incurred due to the actions allegedly made by Mr. Wade and herself. And that's going to be a big question. Politically, for Fani Willis, there's a big discussion over whether she can survive this even as the district attorney. For those of you unfamiliar with local criminal justice politics, Fani Willis is in her first term as the elected district attorney of Fulton County, Georgia's largest and most busy criminal circuit. She took the position from her incumbent boss, Paul Howard, who was chased for years with allegations of impropriety. In fact, he just won a case involving sexual harassment in federal court at the close of 2023. There were multiple sets of allegations involving inappropriate conduct within the Fulton County DA's office, and one of the things Fani Willis pledged when she was running for district attorney was to clean up that office. Unfortunately, that does include some statements she made about interpersonal relationships. We're going to have to see how this really all settles out, because there is a ton of information. It's like drinking from a fire hose.
Yeah, there is a ton of information, 176 pages of information. And again, this is just the answer to the lawsuit filed by Mr. Roman. And then we've got all these other elements. We got the House Judiciary Committee subpoenas. We've got the local lawmakers, Georgia lawmakers, investigating. And then we've got the Wade divorce case. And again, this is just the answer. And so what happens after the answer? And I'm talking about just in this lawsuit. What?
Just in this, Miss Merchant, I almost guarantee, is sitting with her team, including her husband and some of the other lawyers that she works with, and figuring out what the appropriate response is. And I will not be surprised to see an additional responsive filing. Well, it's not a counterclaim because it's not a civil issue, and that would be for damages.
But Roman filed a lawsuit, so that's civil.
That's going to be the civil FOIA issue. But this is related solely to the criminal case, so there's not a counterclaim, but there will be a responsive brief to this answer that Ms. Merchant can file on behalf of Mr. Roman, refuting the defenses that Ms. Willis presents in this response.
Okay.
There's a complaint, there's a responsive brief, and then Ms. Merchant is going to have her own responsive brief.
Okay.
And then, believe it or not, you can just keep going down this circular firing squad forever until we get in front of Judge Scott McAfee, who is charged with determining what to do. A heavy burden for one of Georgia's youngest and least experienced judges, but someone who has impressed everyone with his professionalism, his academic strength, and skills managing a case that no one could have envisioned 5 years ago.
So if the answer is 176 pages, what's Mr. Roman's team going to write back? How long is that going to be?
The most important parts are going to be this first, 20 or 30 pages of substantive argument. The rest of it, starting with Exhibit A, which is page 30, these are going to be all the documents that were submitted in conjunction with Fani Willis's answer. This 30 pages is the actual argument. So this 30 pages is getting analyzed thoroughly right now by lawyers across the nation, and it will be up to Ms. Merchant to determine whether she wants to file a written response in advance of the 15th, or if she wants to hold her cards closer to her vest and just appear, because it does seem at this point that in just about 2 weeks, everybody's going to get to Fulton County in a little courtroom and hash this out.
And I do want to let our viewers know that at any moment now we are expecting our political reporter, Doug Reardon, to join us with some of his insight. Of course, you know, he is typically at the state capitol. He's also getting responses from various local officials and so forth. So we're expecting him to join us at any moment now. But in terms of just this particular lawsuit, so we have this answer from Fani Willis, and then when it comes to the subpoena from the House Judiciary Committee, which came out today in that letter, what's the timeline there? When do we expect?
I'm going to want to see the actual subpoena from James Comer. There should be dates included in it, but again, I fully expect Fani Willis to deny that request, reject the subpoena, which will subject her to some sort of additional action, unless she really does want to participate and submit to the authority exercised by the House Judiciary Committee. That has been a bumpy road here recently, as we've seen with multiple federal panel subpoenas being ignored. Peter Navarro was just up on trial for this. Steve Bannon has a history with this. Hunter Biden has an issue with ignoring House subpoenas currently. This is not settled law, and more than any time in our nation's history, people are ignoring a direct subpoena order from the federal government. That would be an aggressive tact from a district attorney who has taken an oath to support all of the laws and processes included in the Constitution. It is really something spectacular that we are witnessing.
I want to ask you, because obviously Roman's team has filed their lawsuit regarding FOIA. Can Ms. Willis file a counterclaim?
Ms. Willis does have the ability to file, or rather the Fulton County District Attorney's Office as an entity has the opportunity to file responsive pleadings in that FOIA case if it wants. But again, that is a limited scope case. It is about the provision and production of documents and whether that provision and production has been slow-walked by Ms. Willis's office and the Fulton County government. I'd be interested in hearing if there's any specific response from the office of the county attorney in Fulton County, because by law and practice, that agency is the lawyer for the DA's office, if that makes sense to anybody.
Okay, so when we talked about what happens next, which is then we'll get an answer from the other side as well.
Yes, there will be an answer filed in that FOIA case in the statutory time. There may be counterclaims. There may be motions if it is alleged that that lawsuit is frivolous or inappropriate. There are some fee-shifting provisions where you can actually go against the filers. There are specific thresholds that need to be met by the courts in order to assess that. But that's a long, slow process, which brings up the number one biggest issue behind all of this, and that's our calendar. Time is ticking. If you are paying attention to the Trump universe in conjunction with our national upcoming election, we all know that former President Trump has just concluded some rather dramatic legal issues up in New York. He has a major criminal case pending in D.C., a major criminal case pending in Florida, and this major criminal case, it is widely believed that his goal in all of these cases, rather than litigate them outright in public, is to move them past the election. That fits directly with his message to his supporters, that he has been mistreated by the system, that this is a witch hunt, those are his words, and that he is being selectively targeted because of the work he's done representing his constituency and in his actions as President of the United States. So if you reframe all of these conflicts, Donald Trump's win isn't winning the case as much as pushing the calendar back beyond November 2024.
And when we talk about that, pushing back, you know, all of this on the calendar, I mean, this could potentially be years, right? I mean,
Absolutely.
You know, I mean, initially we thought that, well, the goal was to really get this to trial, perhaps even in 2024. I mean, but it seemed to be an unrealistic goal.
It is regular and usual in major criminal departments in Georgia and elsewhere for major felony cases to take multiple years. And so this is already moving at a little bit of a faster pace due to its issue. If appeals start becoming an issue, which that is certainly what people are looking at, the appellate courts move at their own pace. And after the appellate courts, you've got the Supreme Court of Georgia. And outside the state system, you have the federal system. And while those judges have acted with incredible speed and alacrity, considering all the various motions and cases that are pending, remember, there's all the removals, there's all the qualifications and immunity cases. Those cases combined could set the actual disposition of this case back beyond months. Years and years, potentially making them moot. If President Trump wins the election, it would change the standing of all of these cases in dramatic fashion.
In what way? How would it change? I mean, because you know, obviously he's the Republican frontrunner. I mean, it hasn't affected it hasn't negatively affected his campaign.
It would be incredible if anybody could answer that with a straight face and with a lot of conviction. Because really, we've never dealt with this. We've never dealt with a president being prosecuted on a state level where he does not have the possibility, or a president does not have the opportunity to pardon someone. In the federal system, his pardon rights, or the pardon rights of a president, they haven't been thoroughly tested. There was a lot of discussion about pre-pardons, post-pardons, hidden pardons, but really, it hasn't been litigated. And that litigation takes time. The longer and longer that time passes, the more that Donald Trump is very happy with his position, remaining at the center of politics, remaining incredibly influential and powerful, and on track currently to win the GOP nomination, as well as put up a very competitive race for president.
But it still doesn't mean that he's above the law. And, you know, you mentioned the criminal cases against him in federal court down in Florida, in federal court in D.C., and let's see, state court. We have a state court here in Georgia. I'm trying to keep track.
There's a lot going on, because remember, we are currently waiting for an opinion from the D.C. Court of Appeals regarding some of the amendment issues, whether he is disqualified for participating in some sort of insurrection. There is the Judge Aragorn ruling, which is the Letitia James case out of New York, which has stakes involving hundreds of millions of dollars. Obviously, former President Trump recently received a judgment of over $83 million in the E. Jean Carroll case. He has to determine whether he's going to appeal and then finance that appeal, because there will have to be cash or a bond posted. Then there is the criminal case being prosecuted by Jack Smith in front of Aileen Cannon in the federal courts of Florida, which now is getting a lot of attention because of the manner in which Judge Cannon is scheduling certain evidentiary issues that relate to top secret evidence. Anytime there's top secret evidence involved in a government case, there are handling requirements. You might hear the term SCIF. That is a secret room where no one can know what happens in it other than the review of top secret materials. How the prosecution and defense receive and function and analyze those materials, it's an important issue. And there are now allegations that Judge Cannon has put her thumb on the scale to benefit former President Trump in that prosecution, which then brings up, is Jack Smith going to be able to appeal out of Florida some of Judge Cannon's rulings, which slows down that process yet again?
Yeah, so a lot of questions. So, in other words, even if Mr. Trump, really irregardless, if he wins in 2020 this year, I should say, or if he doesn't, I mean, he could still be facing prosecutions for essentially years in multiple states.
Absolutely. There could be additional state actions. I know multiple states investigated the same kind of theory in Georgia as these false elector cases, and whether that was a fraud. There are multiple investigations in states regarding the actions of state legislators and citizens in allegedly trying to, steal the election for President Trump versus the other way around. And who knows what the status of those investigations are. The statute of limitations for all of these charges in all states would be multiple years. And that means that strategically you can wait until one state's process is done before considering to initiate another state's process. And that happens regularly.
But these processes have already begun. So, I mean, correct me if I'm wrong, but the statute of limitations is to begin the prosecution. But these prosecutions have begun.
Some of them have, but what I'm telling you is that some of them haven't. There are potential prosecutions that have not had an official charge brought. And when you look at statute of limitations, there has to be a charging document filed within the necessary statute of limitations. In Georgia, all of your felony statute of limitations are going to be multiple years. Misdemeanors, it's 2 years.
Okay.
For felonies, it's very common for it to be 5, 7, or even more years.
Okay.
So this isn't something that gets extinguished automatically, and depending on who's in charge, who wins elections, who's in power and who's out of power, the perspective of these prosecuting units can change dramatically.
Thank you so much. Okay, Josh Schiffer joining us, a criminal defense attorney based here in Atlanta. We really appreciate your expertise and analysis. I also just want to let our viewers know, we're about to return you to your regular programming, but our live television broadcast starts at 3 p.m. and we're going to have live team coverage of these latest developments. Fulton County DA Fani Willis answering the lawsuit by a Trump co-defendant. Also, again, AtlantaNewsFirst.com is where you can find the entire lawsuit, okay? Like, you can find, I should say, not just the lawsuit, but the answer, more importantly. The answer, I'm just trying to do the electronics for you. So go here on AtlantaNewsFirst.com. You can read all 176 pages of this answer by Fulton County DA Fani Willis just into our newsroom a short time ago. Also, encourage you to subscribe to our YouTube channel, but you can find us anywhere you can stream, which is Apple TV, Roku, Amazon Fire, YouTube. Yes, subscribe to our YouTube, AtlantaNewsFirst.com, and of course on our free mobile news app. Thank you so much for joining us. And if you haven't done so yet, one more thing that's really helpful: sign up for download our app, sign up for alerts, and then you can get news sent right to your phone. So you're always in the know, and you get those alerts, you get those pop-up messages, and you know what's going on. All right, thanks so much for joining us. Have a great day.
Tons of typos. Ton.